Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. Good morning and welcome to the Supreme Court of Texas. We will hear argument in 4 cases this morning. The first is 230507 Mehta versus Mehta from Denton County in the Second Court of Appeals. The second is 230927 Cromwell versus Anadarko E&P Onshore from Loving County and the 8th Court of Appeals. The third case is 231039 In re East Texas Medical Center, a mandamus petition from Smith County and the 6th Court of Appeals. And finally, 240258 State of Texas against $3,774.28. An asset forfeiture case from Potter County and the 7th Court of Appeals District. The court has allotted 20 minutes for each side in each of these cases. We'll take a short break between the arguments. The arguments can be watched online this morning and will be available on the court's website later today. We're ready for argument in 230507 Mehta versus Mehta.
May it please the court, Mr. Lucisano will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning, Your Honors. May it please the court. In order to qualify for an award of spousal maintenance under Section 8.051 of the Family Code, a spouse must, quote, lack sufficient property, including the spouse's property, on dissolution of the marriage in order to provide for the spouse's minimum reasonable needs. A court assessing such an award must therefore do 2 things. First, it must consider what constitutes the spouse's property in the first place, and second, it must then conduct a fact-bound balancing of that property against the spouse's own needs.
So let me ask you, let's say if we were to agree with you that child support should not be included in determining what the spouse's reasonable minimal needs are, then what would you say, how would that exactly work? Or what are you proposing? That we just wouldn't include it, period? Or then would the payee then have the responsibility, the payee meaning of spousal maintenance, to prove what his or her expenses were, or how do you propose that would work?
I think, Your Honor, it's sort of the flip side of what the spouse needs to prove in the child support context for an above guidelines child support award. You have to prove the, quote, proven needs of the child. And so spouses for years have been allocating the expenses of just the children. What we're advocating for is sort of the flip side of that, which is, yes, if you exclude child support, which we think the plain text of the statute excludes, you need to focus on the expenses of the spouse. Now, for discrete child-only related expenses, that's easy. You just don't count them. It gets a little more difficult with respect to non-divisible.
How about the situation where, let's say, and let's just make this easy because this is going to apply to a lot of cases across the board. So let's say you have 2 spouses who both make the same amount of money. And let's say that there's 3 children and child support is ordered at $500 for the 3 children. And so the payor is paying the payee. And so I think the presumption is that that $500 is not going to cover all of the child's expenses, because when you look at 3 children and you look at how much it costs to feed them, to clothe them, to give them a warm bed and a nice home to live in and extracurricular, all that, it's going to be more than the $500. And so presumably the other parent, the one that is the payee, is also paying money for the child, right? So in other words, according to this scenario, it would be the same amount because they're making the same amount of money. So theoretically, the payor is paying $500, the payee is paying $500, and so should that $500 be deducted also before looking at what that number is to determine whether or not that person can meet his or her minimal needs?
I think, Your Honor, it would under the construction we're offering. I think the way to remedy that, the gap between the child support award and, in your hypothetical, the needs of the children exceeding it,
right,
would be through Chapter 154. the
Right.
above guidelines award that I was discussing earlier. You've proved that the proven needs of the children are such that the guidelines award is not sufficient, and it's a matter of the trial court judge assessing that.
And then the payee would do that.
The payee would seek that
In
above.
figuring this out, yeah.
That's
that makes
right.
sense.
Our point is that you can't then sort of mix and match spousal maintenance and child support and use one as a credit against the other.
Right.
And it's not just a matter of mere labels. There are
But you
real.
seem to be offering a categorical rule, the flip side, which is that no child support should count toward determining the minimum reasonable needs or the available property for the spouse seeking the spousal award, the spousal maintenance. But what about something you just touched on, which is that the spouse seeking the maintenance derives some benefit for expenses that are not perfectly divisible. So in this case, the cost of the mortgage, for example. What do we do about that?
I think one approach, perhaps the better approach, would be to treat it as the spouse's expense, because it's an expense the spouse is incurring irrespective of whether the children are in the home, and then to assess how to unwind that through the minimum reasonable needs requirement. Is this a minimum reasonable expense?
That seems very complicated. What about gasoline?
I think that travel expenses would fall into that non-divisible bucket.
And so you just charge it all to the spouse?
I think you would assess it through that lens, but I don't want to fight too hard on that. I think that
Well, we're just trying to figure out something that will actually work.
I think what courts have done in the above guidelines child support context that I was discussing with Justice Learman earlier is allocate the best they can, using their discretion at a trial court level, those types of non-divisible expenses. The Coburn versus Moreland case out of the Austin Court of Appeals allocated a third of the mortgage to the children. The court affirmed that on appeal. The point is that these are highly fact-bound discretionary decisions of the trial court, and we're here in this context, of course, in which this sort of segregation argument wasn't made in the trial court, and so it's difficult post hoc to try to untangle those sorts of non-divisible
But
expenses.
you're not disputing the idea that double counting shouldn't be permitted. As I understand it, you're saying it can be complicated and challenging, in fact, specific, case specific, but in principle, a district judge should not award the same amount in child support and in spousal maintenance.
That's right. That's right. Our position ensures that whatever the overage is on one side or the shortfall on the other, it accounts for both of those support streams separately. And the reason that has to be so is because there are different terms and conditions under the Chapter 8 and Chapter 154 that attach to each of these support streams. For instance, the duration of child support. It ends, generally speaking, when the child reach age 18 or graduate from high school, some other sort of majority-reaching point. Spousal maintenance terminates either 5 years, 7 years, or 10 years or shorter, as in this case, depending on when the spouse can meet their minimum reasonable needs. So if we're
Theoretically, shouldn't you end up in the same place? So if you include child-related income and child-related expenses, including child support, and then if you include the child-related income in calculating the spouse's minimum reasonable needs, including child support, and then you subtract out the child, any expenses related to the children, you should still be left with whatever is available to meet the spouse's minimum needs. And by the same token, if you exclude both of those, would you still end up in the same place or not?
I think, Justice Busby, that's why this question hasn't arisen until now in many cases, is because most courts do what you're positing, which is, okay, if
Just
we
throw it all in.
If we do count child support, then we count the child expenses under the family code. It's presumed that they're reasonable approximation, so we set them to the side and we're focused on what's left. The problem, the reason it came to such clear focus in this case was because the Court of Appeals looked at itemized amounts only. It said, here are the itemized expenses, and here are the itemized property, including child support. And because there wasn't itemized evidence of what those child-related expenses were, it caused this dramatic divergence between the two. So here, applying the statute, backing out the child support, it really mattered under the Court of Appeals analysis, which considered these just sort of what have you itemized amount. But
Let me ask you this. When they were doing that, I understand that the testimony was very vague, and it was just like, well, I have a mortgage, and I have taxes on the property, and because that amounted to what, like $2,750 a month, and that was kind of all there was to it. And so whenever the trial court or the Court of Appeals was looking at that, did they deduct out the amount that would have been paid for the child support in determining that she had enough and so she wasn't entitled to the alimony, or do you know? Can you tell from the record?
From the Court of Appeals opinion, they did not deduct out on the expense side of the equation the expenses that of course are going to the
So
child.
they were just assuming that because what she listed was mortgage and property, they didn't assume that there would be any expenses other than that for children, for anything, right?
I think they treated it as there being no evidence of that because it wasn't.
It was sufficiency of evidence issue.
Right, they considered only evidence that was, demarcated in pure, precise dollar figure terms.
What is the trial court supposed to do in that situation? I mean, you would expect someone arguing about maintenance and child support to come and have an itemized list of what their expenses are. I mean, would it have been appropriate to sort of look to some government guideline about what would take judicial notice of some sort of what it costs to maintain a family or household, or how do we fill the sort of evidentiary problem that appears in this record?
So I think what the courts of appeals have held is that an itemized list of expenses is perhaps the best evidence of what your needs are, and we don't dispute that in any way. The point is that there are other circumstantial indicators in this record, and you can imagine others, that are simply getting at the binary question of, was Ms. Mehta's property sufficient to meet her minimum reasonable needs?
Right, and in cases where it's very thin, do you advocate that the trial court could just take judicial notice of some numerical standard that is out there somewhere?
I would point the court to the Goodfellow and the Trueheart cases, which are at 32 and 42 of our brief. In those cases, the evidence, much less evidence than in this record, was simply the spouse's earning capacity at, I think it was $8.50 an hour, $7.50 an hour, and the Court of Appeals inferred or held that the trial court could have reasonably inferred that that was not sufficient to meet one's minimum reasonable needs. I don't know that that's a matter of judicial notice or just reasonably inferring from the record.
Or just a reasonable fact finder determining that it's not reasonable to believe that only the mortgage and the taxes are all the expenses of that family.
That's right, and just to be clear, Justice Huddle, in terms of what the evidence was, if you look at Volume 2, page 221 of the reporter's record, Mr. Mehta testified that Ms. Mehta's income, financial resources, was insufficient to pay for the mortgage. And the byproduct of that, Justice Learman, is that her other expenses, the ones that weren't itemized or deduced to some precise dollar figure, were high enough that it caused that shortfall. And that's all the court needs to do under Section 8.051, is to make that conclusion.
But that was before the child support was added too, wasn't it?
I think he offered that testimony at the divorce trial, at which time child support was being paid.
Was he referring to the child support and her income as being inadequate to pay the mortgage, or just her income?
His testimony was sort of unequivocal, or at least not qualified in that manner. It was her financial resources, her income, are insufficient to afford the mortgage. Apart from that, Your Honor, if you look at...
And if we're not treating child support as her income or her property, then, which I think is your theory, then that would suggest that it's referring to what she has herself. But then you get the child support, which presumably will cover some degree of the housing, which is obviously a basic need for the children. Do we have any basis to think that wouldn't change the calculation?
I do think we do in terms of, there's evidence in the record, Husband's Exhibit 8 at pages 2 and 13. Ms. Mehta had $48 in her checking account upon the last property inventory pre-divorce, whereas she had over $5,000 of credit card debt. That's in the interim of child support being paid, but the spousal maintenance expiring months earlier in 2021. So we have sort of a test case for whether she was cash flow neutral or cash flow negative, as the case was. And so there was evidence collectively that regardless of whether you separate out the child support for her expenses, a reasonable fact finder could have reached the conclusion that her minimum reasonable needs were not being met.
That part of that is, when there is a divorce, the amount that each spouse receives in terms of assets is roughly half. And often, the house is the principal asset. And when you divide the community estate in half, neither side can afford the mortgage. So is it just the mortgage that is an indicator of minimum reasonable needs? Or is it that once a community estate is divided, the housing needs have to change for each spouse, because the assets are no longer sufficient to cover the house? And I'm not really speaking to this case specifically, but to all cases where the parties divorce and have a mortgage.
I think you could hypothesize a situation in which the house, upon division, no longer became a minimum reasonable need. Here I don't think that the evidence certainly wasn't conclusive or prevented the trial court from concluding that it was a minimum reasonable need as a matter of law. Ms. Mehta was, of course, awarded the house in conjunction with her joint managing conservatorship and her right to designate the primary residence. So I don't think that there should be a categorical rule that you have to reassess or divest the real property, and courts of appeals have held that in assessing minimum reasonable needs, you don't have to divest that real property or spend
The
long-term
Court of
assets.
Appeals said that the evidence established $2,788 in monthly reasonable need, minimum reasonable need. Do you contest that?
We don't dispute that that is what the itemized amount, or that there was $2,788 of itemized mortgage and property tax expenses. Our point is that that is not the only probative evidence of what the needs
Right, but
were.
what the Court of Appeals said, the Court of Appeals said that's all the evidence establishes, that she just didn't she didn't do what she needed to do to establish any greater need than $2,788 a month.
We do dispute that, because the testimony that I referenced to Justice Huddle earlier, where Mr. Mehta held that she could not afford that mortgage, is itself evidence that the other expenses were such that they couldn't be met with her property.
Because what the Court of Appeals said was, well, she gets $2,500 a month, at least gross, but she didn't put on any evidence of net in salary, and then she's got the additional $388 a month or whatever. So mathematically, at least in the Court of Appeals' mind, just ignore child support. I know the key issue here is, can you consider child support? But even if you ignore child support, aren't we just really dealing with a no evidence question on whether the $2,888 a month is enough to cover the $2,788 a month?
We are, but we know it's not, because of this other circumstantial
And
evidence.
so if it's
indicating-
not, if you're right, that the evidence, that the Court of Appeals incorrectly concluded that there was no evidence of greater need, then how do we ever even reach the question of whether child support matters here?
Well, I think once you back out the child support and you have the $88 difference between just her mortgage expenses and her property, then you have the sort of situation where the trial court could certainly reasonably infer. And I see that I'm over my rebuttal time, but
Any further questions?
thank you.
Thank you, counsel. We'll hear from the respondent.
May it please the court, Mr. Wysocki will present argument for the respondent.
Counsel, Justices, good morning. Michael Wysocki, attorney for the father in this case, Manish Mehta. Don't want to disappoint the courts. I'm not an appellate lawyer. That's my partner. She's pretty good at it. I'm, not to quote Kevin Fuller, but I'm a lowly trial lawyer, just trying to make a living. In this case, I've been asked to be here today in relation to the matter before the court. And as a trial lawyer, I want to start out by answering a question, the question being, what is spousal maintenance? The courts
Well, that's what I want to get at. What language in the statute do you rely on to support your position that child support should be included? The statutory language.
Yes, Your Honor, with regard to that, the statute specifically refers to, as the court knows, the property received, essentially the property of that spouse, whether that spouse's property, resources, et cetera.
Right,
And
so where does it refer to child support?
It does not specifically use that term. And so we have to derive, as many courts have done. I think the courts are aware that whether we look at Waco or whether we look at El Paso or whether we look at the Houston First District or Fort Worth or Eastland, I mean, I can keep going down. They all seem to have defined in multiple cases that property as it is under that spousal support statute includes child support.
But largely without explanation. So I'm just asking.
There has been no bright line statute, Your Honor, using that word, but we can look at the family code. And as a family law practitioner, when I looked at this, that first thing, again, that trial lawyer thing, what is spousal support? Well, the courts have said that it's temporary and rehabilitative support above the resources and property awarded to a spouse. Opposing counsel's brief says it is a payment intended to fill the previously unmet spouse's needs gap. Well, for me, it's something extra. It's something extra beyond the property awarded to them. We're saying, does this spouse need something extra?
Well, and in this case, it was ordered for a relatively short time, and could that be the time necessary to reassess the housing situation for her and the children?
Well,
in other words, it takes time to sell a house and to come to the realization that, you know, your financial situation has changed. And could the trial judge have said, she's not bringing in enough income to remain where she is?
Sure.
But she has nowhere to go, and so here's the time associated with that. I mean, that just seems like what a reasonable trial judge could do.
Happy to answer that from a trial lawyer perspective, Your Honor. That's why we have that gap of temporary orders. And it's why oftentimes on final, that trial lawyer or that trial judge knows that spouse had all of that time. And if the court looks at the record in this case, of course, we're not here to analyze the evidence. It was very clear in this case that the spouse had made no efforts to get a job, no efforts to obtain any kind of different housing, no efforts to obtain additional income. That's all in the record. We cite that in our brief. You're welcome to see it. And so then sometimes when that trial judge knows that, they say that spouse had that chance. They had that opportunity. I don't think that's what we're here on, though. But
right, because the trial judge in this case said, no, I disagree. The spouse did what the spouse needed to do during that interim and needs a little more time. So the trial court viewed the facts differently.
I'm not sure.
You're not sure? Well, the trial court awarded the maintenance that we're here about.
With regard to that, if we look at the family code, with regard to that something extra, are there any other places in the family code where we address this idea of something extra? Opposing counsel hit it right on the head when he got up here, because he came out of the gate and he said, well, look at the above guideline child support. Well, that is exactly right. The family code, this idea of something extra is not novel. The family code addresses it in the above guideline child support section, and that is 154.123. Under that section, above guideline child support is something extra, above what the code says should be awarded in child support.
But it wouldn't, but where do you get that it would include child support, which is there's a whole chapter on child support. It is more than defined.
Absolutely, Your Honor.
Great detail about child support and it being for the child, not the spouse.
If we look at that same section, 154.123, which is the above guideline child support section, says that under subsection 8, what do you consider in determining whether the child, because opposing counsel has created this two-bucket situation is the way I look at it. We have a child support just for the child, spouse support just for the spouse. Well, guess what you look at in that above guideline child support section under subsection 8? Spousal maintenance received by the party. So in other words, the parent in possession of the child, we look at whether or not they're receiving maintenance as to whether or not the child should get above guideline child support.
Well, I assume because the parent always has the duty to use whatever the parent has for the child, but I'm not sure that it goes the other way around and the child has the duty to use child support, which is supposed to only be for the child for the parent.
Well, and that's an interesting concept. And so when I looked at it here.
Before you answer that, I want to make sure I'm understanding. I'm trying to view everything you're saying through the lens of this question.
Yes.
It sounded like you said that child support should categorically be considered. Is that your position?
Absolutely. And here's why. The reverse, what I just heard argued up here at this podium, would harm families. And let me explain to you why. Justice Lehrman hit it on the head when she said, what if the child support, and she referenced the $500 in child support. Family law practitioners know child support never covers all of the child's expenses. I've not in 22 years seen a case where I felt that child support covered all of the children's expenses. Okay, so in this case, if we use their rule and we do this factoring where we back out, so in this case we have 3 children, 1 mother, we take the house mortgage, we divide it by 4, we attribute 25% to her, 75% to the kids. Then we do the same thing with a car payment, same thing with a utility payment, same thing, same thing, same thing, same thing, same thing. Down and get down the board. She's never going to be able to show that she has inability to meet her minimum reasonable needs. Because you under his theory, you back out anything attributable to the children. Perhaps that's why.
You said that the child support will never meet the full needs of the child. But then you're also saying that it must be considered against the parent for spousal maintenance, which means, I think, that amount, which you've just said isn't enough to support the child, ought to be considered as supporting the parent.
Because the reverse of what I just pointed out. If you back out the expenses of the child from the parent's inability, because again, the case law is clear. The best way to do it is you do this list of expenses, right? You put on evidence of this expense, this expense, this expense. Well, when you take those and you back out the portion attributable to the children, or child or children, right? And then you have what's left, that is worse than just leaving the child support in. As a rule,
Why is that worse? I'm not following.
Because Judge, in this case, so let's say, let's use your example. Child support's $500.
Yeah, make it simple.
Okay, child support's $500. We take it out and we put it over here in this child support bucket. But then over here on mom's side, there's a mortgage. We'll just say $3,000. There's a car payment, $1,000. Utilities, this, that. Let's say there are 2 children, 1 spouse. We take 2/3 of the cost of that mortgage, 2/3 of the cost of that, 2/3 of the gas, and we move it over here into this child support bucket. 2/3 of all of those things is much greater than that $500. And so we're pulling expenses off of that parent seeking support's side greater than the child support they're receiving.
You assume that all those expenses should be divided evenly, but, you know, if you live alone, you still have to take out the garbage, which is one reason why you should never have to complain about taking the trash out, right? And so the same thing, you know, if you live alone, you still have a car, you still drive everywhere, you know, so it's sort of, it seems to me like we're trying to make some sorts of categorical rules for something that's very fact-bound.
Even in those cases where the courts have done adjustments. So let's say they don't attribute the full 50% of the mortgage. Let's say they only attributed, the case he cited, I believe, was 1/3 of the mortgage, or 30 or 33% of the mortgage. Even in those cases, in even giving a break, those expenses that are pulled out are more often than not going to be greater than that child support paid.
So what if we don't have to do it the way that you're talking about, you know, we're the ones that set the rules.
Of course.
And so let's say if what we did is we looked at how much the payee would be paying in child support if you looked under the guidelines, and under my hypo, it would be $500 because they're making the same income, okay? So you have $500 here, $500 here. So you have, so you're not going to include the $500 over here, but you're going to deduct the $500 over here for that amount of money that's going to be paid for the child, and then the remainder is the amount that's would be able to satisfy or not that payee's minimal reasonable needs, right? And so that's why I'm not following how you're. Seems to me that that's kind of what you're saying, but then you're saying that somehow. The result is that you should include the child support in it, and that seems illogical to me. Okay. And I think we're having that problem here with what you're saying.
In that case, and under that scenario, what other expenses of the children are we going to deduct out?
The 500, under
And
the,
that-
under the
and-
guidelines.
And just nothing else.
Right.
But even though we know that there are a
Under
significant
that
other.
theory, you're just looking, assuming, because, all of this is, not exactly an exact science. So we're just assuming that under the guidelines, that the legislature is presuming that this is how much the payor should pay, and that a payee should pay the same amount. You deduct that, and whatever's left, that would be the amount that's left to meet that person's reasonable minimal needs. Wouldn't that be a way to do it? I guess even if we didn't do that, I'm not following how this theory of deducting the amount from the payee, whatever it is, if you do it under guidelines, if you just guess, whatever you do, I don't see how the result is that you add the child support back in. That's what I'm not following the
Yes, Your
logic
Honor.
of that.
And that's why I referred the court to 154.123.8, because it's exactly what we do in the circumstance of above guideline child support. It's exactly what we do in the reverse.
But why would we
add-
do it? Just explain that.
Yes, Your Honor. Because of what I heard from the collective up here isn't it kind of all together? It is. When you're in a household, I don't sit around and decide what's, Ava's expense or Barrett's expense or Audrey's expense. It's the household, Judge. And in fact, we see this concept of household throughout the family code. We see it under 154.070, where in that case, and very similar to this, because it goes to their brief where they talk about the child support being quote-unquote in that child bucket. Under 154.070, under a multiple household situation, a parent who is receiving child support in one scenario, but also paying child support in another, the child support that they're receiving in that other case is added back into their net resources under 154.070 under a multiple household situation, and thus considered in the amount of child support they pay to the child over here. So under the theory posed to y'all this morning, that statute would fly in the face of the rule they're trying to get you to make. Because they would say, oh, no, that child support that this parent is receiving, because they're the custodial parent of one child over here, you can't consider that Texas Family Code 154.070 because that's that child's money, and you can't take it into consideration in the net resources of that parent to then pay child support to this child. 154.070 does exactly that. It adds the child support back into net income. We see that in multiple cases throughout the family code. Multiple cases.
Just to be sure I understand the numbers, so if you've got $500 in child support.
Yes, sir.
And you do the allocation that you were talking about, and you move, a certain portion of the mortgage, a certain portion of all of that stuff, and that adds up to $1,000. You've got a shortfall of $500. And so it seems like you should subtract that out when you're calculating how much is available to meet the spouse's minimum reasonable needs, because the spouse has to meet that from somewhere. You agree with that?
I think under the rule proposed that I heard argued from the podium, which is, so you don't include the child support, but then you also don't include the children's expenses. I think
It seems like you come out worse under the rule that you're advocating, and I'm
I
trying
think
to understand that.
I think that the parent seeking spousal support comes out worse under that rule. When you pull the child support out and you pull all the child's expenses out and you say, because again, the way I had done it when I read through this is I see opposing counsel arguing these two buckets, which I can cite all the statutes in the family code that completely disagree with the two
I'm
buckets.
sorry, you
but
said who turns out worse there? I'm sorry. I
The
didn't
parent
hear you.
requesting spousal maintenance comes out worse there.
But if
I
you
think-
do it the way you're talking, if we were just discussing, you put it all over here and there's a shortfall because the child support, as you said in your brief as well, and I think everybody realizes the child support is not usually enough to cover all of the child's expenses, or children, however many there are. And so then it seems like you have to take whatever that shortfall is and subtract it out from the spouse who's seeking support. You have to subtract that from the amount that's available to meet their minimum reasonable needs.
If we continue with the manner I'm advocating, which is the way that all of the appellate courts I mentioned earlier are doing it, where child support is considered, and the parent.
And the expenses are also
and
considered. The
yes,
children's expenses
yes,
are also.
The parent identifies their expenses essentially financial information
Their,
statement.
their expenses being the parent's expenses or the child's expenses?
It's their,
Both.
their household expenses. We call it a financial information statement of income. So you prepare an FIS, and you have these expenses, and you consider all of the parents' resources, which I can cite a number of cases or a number of laws in this family code that include child support as resources, or earnings, or otherwise. And then we define property as income and earnings under the family code, if we're getting into definitions. But in that scenario, Judge, where we do it the way a number of the appellate courts have done it, and you leave everything over here, you identify all of those expenses, you leave in the property of the parent, whether we, including child support, and then at the end, there's a shortfall, of course. Well, that's exactly what the, that section of the family code under the spousal maintenance statute is referring to.
And
that
normally,
actually works out-
your rule will be more favorable to the spouse who's seeking support.
Yes, sir.
Spouses.
And significantly more favorable, let me just be clear, significantly more favorable. And we
And the
see
reason it's
that,
not in this case is because some of the expenses weren't quantified.
and I said it that day when the judge ruled, I was like, well, that's not gonna be upheld, there was no evidence put on. And there wasn't.
Wait, you said what?
There was absolutely no evidence put on of expenses.
So let me get this clarification. The Court of Appeals held, quote, based on the actual trial evidence, wife's monthly minimum reasonable needs were only $2,788. Petitioner's counsel argues that that's incorrect, that that's error, because in the record, there is actually evidence of greater need than $2,788 a month. Do you agree or disagree with Petitioner's counsel?
I disagree.
Okay.
I was there.
So if you're right, and the Court of Appeals was right, that wife only proved $2,788 a month.
Correct.
Then you compare that to, okay, then what's her income? And what they said was, well, based on, the Court of Appeals said, liquid assets divided up on a monthly basis is $375 a month, and income from her salary is $2,500 a month. Now, we know that's gross, but they dropped a footnote saying, but she didn't bear a burden to show them what net was, so we're gonna go with gross. So Court of Appeals says $2,850 a month is her income, $2,788 is her reasonable need in terms of what the evidence proves. You agree with both those? That's the evidence?
Yes.
Okay.
Yes.
And if that's true, then why does child support matter in this case? If that's correct, that if the record only proves $2,850 income, $2,788 needs, it meets her needs. So the fact that the Court of Appeals threw in this almost passing statement that, and when you also consider child support, she's $2,800 over what her needs are. It seems irrelevant to me in this case.
I think that it shows to me an understanding of the appellate court with regard to the circumstance that any expenses related to the children were not backed out. The appellate court, in that analysis, did not back out from the mortgage, did not back out from the taxes, did not back out. Again, they reference a case where a third was backed out. In this case, we have 3 children. 75% wasn't backed out, a third wasn't backed out, anything. So the Court of Appeals is saying, even without attributing any portion, and this is how I read it, without attributing any portion of that mortgage, without attributing any portion of those taxes, without attributing any portion of what she actually proved as needs to the children, and including child support, she's still way over. And so that's how I saw it.
Let me ask you something. So in a record, when you have evidence that there's a mortgage and there's taxes, and
Yes,
that's, about 2,700 and whatever, around that amount. And there's also evidence that there's 3 children, that there's an adult, so there's 4 people that lives in that home, and that they live in that home. Is that not circumstantial evidence that there's going to be more expenses, for example, for food and clothing and electric bill, et cetera? Is that not circumstantial evidence of that?
I think it requires the trial court to make a massive leap in assumption of evidence.
How so? I mean, they're people. We know human beings have to have food. They have to have certain things to live. Let's just take food alone. Food. If there was no food, they would starve. And I don't see how that's not circumstantial evidence of that.
What about the reverse, Judge? Are we to assume that they have free food coming in from a meal service, that they have free food coming from a food bank? Are we to
Perhaps.
assume because she works for a nonprofit that she's getting nonprofit?
Perhaps.
And so, again, are we going to assume it this way, but are we also going to assume it back this way? And so that's why we rely on evidence that was actually presented.
We rely on circumstantial evidence all the time.
In this case, when we're talking about something extra, and that's, to me, that's the distinguishing factor here. We're talking about something above and beyond. We're talking about something above and beyond a property award, just like the above guideline child support section. And I would, judges, I would say, look at how we do above guideline child support. We add it all back in. We say, what are the expenses of the child? Okay, we have private school, we have extracurricular activities, we have this, we have that. We itemize it to prove the above guideline needs of that child. We add back in under 8 whether or not the parent is receiving spousal maintenance. So we have a total add back in. And the reason we've done that under that above guideline child support section is the same reason you would want to do it as it relates to spousal
Well, I don't
support.
disagree with that. I'm just saying, looking at what we would determine is an insufficiency point to the point that there's no evidence, which is what we have to do because we only have legal sufficiency review.
Yes, Your Honor. Just like in that, the kind of the standard of evidence we require an above guideline child support case, I see that same basically standard being applied in spousal maintenance cases because it is an extra. It's an above. It's an above award. Spousal maintenance is something, again, I use the word extra. And in that, just like in above guideline child support, where you have to itemize out the child's expenses and what makes it necessary for them to have above guideline child support, that's the same thing that we do in spousal maintenance. The parent needs to show, I have all of these extra expenses to where my household is at a shortfall, and you prove those. In this case, Your Honor, again, the minute the judge ruled, I kind of leaned my head back and I was like, well, that's going to get overturned because there was absolutely no evidence on it.
Thank you, counsel. Your time has expired. Are there any further questions?
Thank you.
Thank you, Mr. Wysocki. Mr. Lucisano, I believe you have 5 minutes.
Thank you.
Thank you, Your Honor. Starting with the statute, Mr. Wysocki cannot point to anything in the family code that indicates that child support should be considered as part of the spouse's property to meet her minimum reasonable needs.
So why is it considering child support if you have the amount of child support and you subtract out the child's expenses so that you can figure out what the shortfall is? Because it seems like you still need to know that to decide what's available to meet the spouse's reasonable minimum needs.
If you include the child support and then
Well, it just seems like semantics to me. What you need to know is what's the shortfall, right, under either of your scenarios. And maybe you say, well, it's all over here, or it's all over there, but you're still doing the same math to say how much more are the child's expenses than the child support, because that's got to come out of, in this case, the mother's property, right? I mean, she's not going to, we've got to presume she's not going to abandon the kids or, not meet their minimum reasonable needs.
it's not semantics for 2 reasons. One, if this hypothetical we posit where the child support is always insufficient, there's always a shortfall, there is a remedy under Chapter 154 for above guidelines child support that puts specific conditions on how you receive additional child support to meet those unmet needs. It's also
and
not
that may be, and maybe it's malpractice if the lawyer doesn't ask for that, but you've still got to deal with the situation that the mother is taking out of her property what's needed to meet these child's needs.
That's right, but you have to account for that under the child support statute, and this is reason 2, because if you collapse the two and you're treating...
Are you arguing that you don't take out the expenses? I didn't understand that.
No, you do take out the expenses.
Okay, I think there's a misunderstanding here. So you're saying that you don't add, that in other words, you do take out the expenses of the child that would be over the amount of the child support that's ordered, right?
That's right. You isolate the two. And if we look at the 2 provisions that Mr. Wysocki cited, the multiple household situation where you include child support and then you net out a credit for the children who are not part of the award, that's doubly unhelpful for him, both because...
It seems that a significant practical problem with your approach is this fiction that you can separate the child's expenses from the caretaker's expenses. And, you know, your friend's point that it's the household's expenses. That's sort of how we think about our own families and how we would think about other people's families and budgets. And it seems your approach will require the imposition of this kind of artificial distinction between the child's expenses and the parent's expenses in every case.
I don't think it's an artificial distinction because I think it's one that the legislature crafted, and it's one that courts already tackle under above guidelines child support in isolating the proven needs of the children. But the problem...
Let me ask you this. Let's say if we were to just set out the rule now, this is what you all need to do. And so you do include child support, but you need to have and I don't mean for people to have to itemize. I went to Target today and I spent $22 and 10 of it was for the children. I don't mean that. But you have to, in a reasonable way, itemize what the expenses are for the whole family, you know. And we remanded for this to be done again because that rule was not clear. Would that be a problem for you?
I think our position is that even if you apply some sort of segregation principle to the evidence of the record, it's still sufficient. But as we've said in our brief, to the extent this court is assessing the evidence and has concerns about legal sufficiency in light of the announcement of that new rule, you know, this court has never tackled the eligibility provision for spousal maintenance in any fashion, let alone announce the rule that we're proposing, which is a plain text interpretation of the statute. And if in light of that, applying that segregation principle, the court has legal sufficiency concerns, then this is a paradigmatic Rule 60.3 remand in the interest of justice.
If we were to agree with the Court of Appeals that this record establishes $2,850 in income and $2,788 in expenses for your client, if we were to agree with that and that there's legally insufficient evidence of anything to the contrary, then does your client lose here regardless of whether you can consider or not consider child support?
If the court concludes that there's legally sufficient evidence irrespective of child support, then yes, I think that would be the right outcome. But I think it's awfully telling. Mr. Wysocki says that, you know, when the divorce decree happened, he was shocked that there was no evidence. We've had many briefs in this case, and 20 minutes today. He has never confronted the testimony of his client that my client could not afford her mortgage. It's substantive, probative evidence that her needs were not being met. And it is a classic case of the discretion of the fact finder to make that decision.
Any further questions? Thank you, Mr. Lucisano.
Thank you, Your Honor.
Thank you to all counsel. The case is submitted and the court will take a brief recess.
All rise.